All right, I'd like to call the Board for Licensing Contractors for Tennessee to order. We'll start with a roll call to my left.
Bill DeMint.
Ronnie Tickle, Memphis.
Andy Allen, Kingsport.
Mark Broad, Knoxville.
Keith Whittington, Johnson City.
Lee Carter, Middle Tennessee.
All right, first item on our agenda is to adopt the agenda or any changes to it.
Make a motion, we adopt the agenda.
Second.
All right, all in favor, say aye.
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 Any opposed? The agenda is approved. Next item is the approval of the meeting minutes.
Motion.
Second.
We have a motion and a second to approve the meeting minutes. All in favor, say aye.
Aye.
Any opposed? That motion carries. All right, license reviews. We'll start with hardships. Any discussion on hardships? Take a motion for approval.
Motion.
Second.
All right. All in favor of the hardships, say aye.
Aye.
That motion carries. All right, the waived interview applications. Any discussion? Is there a motion for approval?
I make a motion that we approve all waived interviews.
And a second?
Second.
All right, all in favor, say aye.
Aye.
Waived interviews are approved. All right, contractor revisions, including increases, added classes, mode changes, and name changes.
Make a motion, we approve.
Second.
All right, any discussion? All in favor, say aye.
Aye.
Any opposed? That motion carries. LLEs. Is there a motion for approval of LLEs?
Motion.
Second.
All in favor, say aye.
Aye.
That's approved. LLPs.
Motion to approve.
Second.
All in favor, say aye.
Aye.
And home improvement licenses.
Make a motion, we approve.
Second.
All in favor, say aye.
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 Those are approved. Applications with factors and interviews. Is there any discussion on those? Okay, so they're all approved? Is there a motion for approval?
Mr. Chairman, I guess no one has any to read before the board, so I make a motion, we approve all the applications with factors.
Is there a second?
Second.
Okay, all those in favor of approving the applications with factors and the interviews, say aye.
Aye.
Any opposed? Those are approved. All right, residential continuing education provider reviews. We have National Technology Transfer, Inc. Does anybody know anything about that? Is that a new company or?
Yes, Mr. Chairman, that's a new company. The first two you see on there are both new companies, and then the final one there are just additional courses of already approved providers.
Okay. Any discussion on any of those three? Do we have a motion for approval?
I'll make a
Motion for approval.
And a second?
I'll second it then.
All right, all in favor, say aye.
Aye.
That motion carries. We'll move on to the legal report.
Yes. So Kyle and I are going to read our changes to the legal report separately. The first change is number 6 on the legal report. That is case number 2024014711. The new recommendation is to authorize formal charges and a settlement offer with a $10,000 civil penalty and 6 months suspension of the license from the date of signing the consent order. The second change is number 84 on the legal report. That's case number 2024016451. The civil penalty is increased from $1,000 to $2,500. And the third change is number 125 on the legal report. That's case number 2024026391. The civil penalty is increased from $1,000 to $3,000.
All right.
Good morning. I have some changes as well,
Okay.
board members. And actually, first, we're going to go ahead and address number 38. That is case number 2024-018-721. It is set for discussion. So we'll go ahead and discuss that one on the record. After looking at that, what are some thoughts of the board members? The case involves concrete. The house is probably less than a year old, but the respondent's position is that some significant abnormal weather in January caused a freeze-thaw cycle that led to this condition. And then we have an expert that thinks it had to do with the finishing and some of the I guess the mix used. So what are the board's members' thoughts on that? And what do you think the decision should be?
My experience with concrete spalled driveways and sidewalks is if the finisher's not, if he adds water to it, you're gonna have a good chance of getting some spalled concrete once it freezes. There could be other issues that cause spalling, but that's typically the most common. If they didn't use air and train concrete, that could be another issue. As far as severe weather, I've not really seen it where it can get that severe to cause spalling of the concrete.
Do any other board members have thoughts on that?
Mark makes a good point, but concrete is going to crack, it's going to freeze at some point. That's one thing that is not guaranteed. It's concrete. Again, we don't know what mixed concrete was, and so that kind of puts us in a bind on that, as well as if it was bad weather for a period of time, it's possible that concrete didn't cure ahead of time, which is no fault of the contractor. It's the nature, and nature did it, and it froze, and that's what causes the scaling. So I don't think it's the contractor's fault. I think it's an act of God.
Any other board members have any thoughts they want to put on the record for this case?
Only thing I would add is I agree with Mark and Ronnie, but I would assume that the contractor had control over the quality of the concrete and what was specified in the mix. And I don't know, did it say that it was a January or winter installation?
So it was before January, and then the extreme weather that ultimately the condition followed after that, where the freeze-thaw cycle happened, was in January when we had the significant snowstorm. Another thing I'll say is that the board only has authority to violate if there's gross negligence involved. So this could be a discussion of whether you think this just is mere negligence, or if it rises to something that the board has authority over, which would be gross negligence.
Any other discussion?
So the board just ultimately needs to discuss and come to a decision on what they want to do with this complaint. You can violate for gross negligence and recommend a penalty, or you can close. If you have any more questions for me, please ask.
I don't think it was gross negligence. It was maybe negligence, but not gross negligence.
Okay. Does the board agree with that?
Well, the homeowner is stuck with concrete that's spalled. And at this point, he either has to live with that, or someone's going to have to replace it. So it's, in my experience, we've had projects where there was spalled concrete, and we've gone back and replaced it under the warranty.
And they certainly can do that, but the question is whether it rises, the board thinks it rises to gross negligence that we have disciplinary authority over, or if you think it's just mere negligence or something that was a little outside of the contractor's control, if the weather had a factor in it. Those are all things to consider.
I think there's a lot of variables involved in this, and that the level of negligence could shift on several different factors. You know, I'm not sure if we have enough information to really determine what went wrong, what happened.
And an option would be, based on what we have right now, to decide to close it, but if there's any further information, then the complaint could be reopened, or further investigated if we have more information.
It appears that the two houses that we're talking about right now are in the same subdivision. If we might want to investigate if anybody else has had that same problem in that subdivision. And then that may help us determine if it was gross. But right now, I just think it was negligence, because we don't know the concrete, if it was 2,500, 3,000, 3,500, 4,000, or 5,000. That's one thing. We don't know how much, going back to what Mark, we don't know how much water they put in, if they put in any. Also, we don't know if they put calcium in your concrete or not put calcium. Calcium makes it dry quicker, get ready to finish. So concrete's a funny thing, and again, the only thing that residential doesn't guarantee is concrete, because concrete's gonna crack. I can pour a concrete slab today, and in the morning, you'll have spider cracks all in your concrete. And even using the right concrete, right PSI. And concrete's just weird. And it's always been. I hate that we have to use it, but we have to use it. If we use this paving over here, but you can't put paving on a slab. So anyway, I'm just.
So it sounds like to me the board's kind of concluding that, based on the information we have, there's not enough to issue a gross negligence violation.
I don't think we want to be the one that determines whether it's gross negligence or not.
Excuse me? Sorry.
I don't think the board wants to be the determinant of whether it's gross negligence or not.
Well, if you don't think it rises to that level, then the board doesn't have jurisdiction over just negligence. But if you think it does, then they do. But so it sounds like to me, based on the information, the board does not think it rises to that level. If for some reason we have another complaint or additional information, it can be reopened and we can look into it further. Is that what the board's deciding?
Yes.
Okay.
Yes.
So that will be number 38. That is case number 2024, 38, 2024-018-721. The board is deciding to close, and that is also number 39, case number 2024-018-491. The board is deciding to close. Few other changes. Number 65 on the legal report, that is case number 2024-019801. That is being changed to a $5,000 civil penalty. Case number 83 on the legal report, that is number 2023-053141. That is being changed to just close. Case number 100 on the legal report, case number 2024-007451. That is being changed. The penalties and the authorization is not being changed, but the board would also like to do a referral letter to the local DA's office. And then number 102 on the legal report, that is case number 2024-023841. That is being changed to close with a letter of warning. And then lastly, number 130, case number 2024-019681, that is being changed to authorize a formal hearing and a civil penalty offer of $500. And those are all my changes.
Do I hear a motion for approval of the legal report as amended?
Make a motion, we approve the amended legal report.
Second.
All in favor, say aye.
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 Any opposed? Okay, the legal report passes. We did that. Okay, legislative update.
All right, good morning. As most of you are aware, we did have a legislative update from a law that passed last session that changed for contractor license application or contractor renewals to require a compiled financial statement instead of the audited or reviewed financial statements. And so the board has received just numerous questions since that's gone into effect. And I do believe that we have answered all of those as best as possible. We've gotten some different questions on that, but that's probably the biggest question that I think that we've received since the last meeting is, what does that look like? We've put out some resources to make sure that the applicants understand, what they need to provide as part of that. And I know the licensing staff has also worked really well with making sure those renewals are processed timely. Because there have been a lot of questions. People have asked about submitting a compiled financial statement for an increase for a monetary limit or for an initial license application, which is not the case. That law only changed it for renewals. But we did have 3 other laws that went into effect earlier this month that we haven't previously discussed. One of them does amend the Fresh Start Act, which the board uses when we have an applicant who has a criminal history. Specifically, this law change prohibits a licensing authority from using vague terms without explaining how they directly impact, or that conviction directly impacts the ability to engage in the occupation or profession. So when we do have an individual with a criminal history, we'll make sure that we walk the board through that, and that we're not using any vague terms that could confuse them as to why they're being denied for a license. And that's found in Public Chapter 788. The next one that we had does change the Employment Verification Entitlement Act just to change slightly how certain applications are processed under the SAVE program. And that's something that the licensing staff will be doing to make sure that someone who applies, if they're not a U.S. citizen, how their application would be considered. But that's something specifically with the licensing staff working on that, and that's Public Chapter 921. And then the last change, which is something that would be something the board would have to engage in, is Public Chapter 944, which was an amendment to add a new requirement for regulatory boards to issue private letter rulings or advisory opinions upon the request of any affected person who's licensed, certified, or registered by the entity. So typically when someone is asked a specific question, sometimes the board staff is able to look at it and say, here's where the classifications are. If someone asks, for example, is there a classification for this type of work? We can point them in that direction. Or typically, if they've asked a specific legal question, we've referred them to talk to a private attorney. Under this new law that went into effect July 1st, if an individual wants to know specifically whether they're engaged in unlicensed activity or if something violates, their licensing terms, that's something the board would look at and consider whether or not that would rise to an advisory opinion or a private letter ruling and would issue that. So we have not received any requests for that. Some of our programs have had questions that really are not an advisory opinion. It's still just basic licensing questions that licensing staff are able to answer and assist with. But once we do receive one of those, we will present that to the board to make sure the board signs off on that before an individual is given such a private letter ruling. Do you all have any questions about any of those laws or any of the previous laws that we've discussed?
Let me ask, going back to your licensing on renewals, do you have a list of what the accountants are going to have to do on both, on the up to $1.5 million and then from $1.5 million up to 3 million or unlimited? Do you have a list like 1, 2, 3, 4, 5, and they fill in the blank so we'll know? Because your county's probably going to ask us
Right.
what they want. Well, I don't know, but if I have a list, I can say you need this, this, and this. Have y'all prepared that? Because it's going to be coming up, and I think now you're, once when we renew your license, I think that's good for 2 years. So have we made rules and don't know exactly what our steps are, or are we good on knowing what our steps are?
I think there are some more guidance that we can give in terms of forms. For example, when we ask for someone who's under $1.5 million, that financial statement, they can use our form or they can submit their own form. But our form is very clear of saying, here's the assets we're looking at, here's the liabilities we're looking at, and they report that form. We may have to create something that they can use as part of that, though. Something specifically for the CPAs.
Yeah, I think we really need that.
Yeah, I think that'd be helpful as well, just not necessarily a flow chart, but just a one-page, when you can use a compiled statement, and when you can't, and
Right. And we did put some of that information out there about when you can use the compiled statement, and I think most CPAs are able to prepare that, but I do think the question about, what information should they include, or should they be asking their client, the, contractor, to include in that statement, that is something that we can certainly provide.
I think that'd be a whole lot, because my accountant asked me for things, and if I don't know what, I'd like to get ahead of him, but
Right.
sometimes it's tough to get ahead of him. Thank you.
No, I understand. I'll make a note of that, and I will work with Chris and his staff to make sure that we can provide that information. And we do have, it's the next item on the agenda as well, but we do have, as part of the authorization for rulemaking, there are some rules that are related specifically to this that will help, I think, some of those. But having those forms on the website always makes it easier. The classifications, for example, it's something we typically can copy and paste that hyperlinks into someone, and they can look at that.
okay, thank you. Chris, do you have a update for us?
Yes. Hey, good morning. Just referencing the my executive director's report, just a total big picture of the state as far as active licenses. There's over 34,000 active licenses right now. That includes home improvement, LLE, and LLP. And so, but going into 2024, we are on an accelerated path for new applications. As you can see, we're well over, we're halfway through the calendar year, and we're well over the mark where we were at this point last year. And so I expect that will continue with new applications. So we're growing at an accelerated pace. That, which in turn will also lead into more renewals every 2 years as well. So we're seeing a lot of growth. And with that, we are working through the total transaction inbox that we have in our system, our core system, and we're making steady increases on reducing that overall inbox. I've been on board here for a little over 3 months, and been keeping pretty good track of where we were, kind of at the height of our backlog, and where we had over 2,500 different transactions about mid-May. As of today, we're down to just over 1,800 inbox items, and so we made significant improvements. That has to do a lot with folks coming on board, getting fully trained on processing, having a full staff. With that, we did lose one auditor back in May, but we have since be hiring another auditor, and that person will be arriving in mid-August. So with that, getting that person on board, we'll be, again, fully staffed to process. So we're making great progress as far as the overall turnaround time for, as a complete system, doing well. I know that there's always individuals that, call in and ask for updates and things like that. We work really hard to get those adjudicated really fast. So we're making great progress with that. In addition to what Jesse was talking about with the compilation language, we've updated the renewal form, online renewal form in Core, just as of last week, to really specifically address some of those issues about allowing compilations and things like that. So, and that also matches the PDF form that they can fill out on paper. So those two items now should match and hopefully streamline and make a little more clear what they need for renewal. But again, as Jesse mentioned, we will work to continually improve that process, and with the goal of getting all the documentation we need on the first time, and that we can turn the renewal around much more quickly. And with that, are there any questions?
Chris, looking at the applications here, and of course, going through the legal and so forth, are you seeing any change, I guess, appreciably in the number of complaints or issues that are coming before the?
I guess my sample size is relatively small, just being on board. I don't know if I can answer that. I know we see a lot of complaints
Yeah.
coming in, but I don't know if that's a lot or a little
Yeah.
compared to what's normal. Again, I've only been here for 3 months, and
I
so.
don't, my experience is pretty small, for here first year, but when I print those out, it's a pretty large list, and you go through those. I just wondered if that was, commensurate with the number of applications, or if it's being reduced or anything like
Yeah.
that, or if it's.
Again, I don't have the information to answer that, but I can definitely follow up and get back. But I know that there are, I don't know if legal can.
So if you all would like, we can pull some numbers as well. My personal opinion is I thought that the complaint total number would have dropped when we were doing more of the citations, as we've gotten our citation process, really robust lately. So we have less of those cases are on the legal report because they're resolved through statutory citation. However, as you all are aware, our legal report is still over 100 cases at every meeting. So it has not dropped that many. I would assume, based on the numbers that we're presenting, as well as the number that we're resolving through citation, that we've seen an increase in complaints. And I would wonder as well, if we looked at the number based on applications, if we're seeing more unlicensed activity on those applications as well that we're issuing discipline on, because it does seem like we are at every meeting seeing more applications where individuals have disclosed unlicensed activity. But if you all would like, we can pull some numbers, end of year, because typically our fiscal year is July through June 30th, and we can kind of look at this past year compared to the year previous, if you all would like that information.
Okay.
We'll bring it to the next board meeting.
Okay. Any other questions for Chris? All right, thank you, Chris. New business. We have appeal of an unlicensed home improvement contractor case.
Now I'll provide an update on that, just briefly. This was a case that went before an administrative law judge, and the individual appealed it to the board. They have the authority by statute to appeal those types of cases to the board for review. we have not had that situation occur, so we have looked at this, and this happened very recently. So because of the way that we looked at it and my superiors looked at it as well, the procedure has changed as to how that's going to be presented. So we'd actually like to push that to the next board meeting. It will not affect, it should not take very long, but essentially the board would just need to consider whether or not they would accept that appeal and want to hear that case directly. But we'll provide all that information at the next board meeting.
Okay. Presentation of rules for approval.
Yes, and I have those up as well. We have gone through several lists of things the board has previously approved, as well as discussions of some rules that we would like for the board to authorize for a rulemaking. So I'll let you know what are some new things and some things that we've discussed previously. But first, I think the biggest thing is related to that law change about the compilations for the financial statements. We need to modify our rules for that, but we also want to add, and we'd like for the board to authorize just some additional requirements outlining specifically that financial statements need to be within the last year being one of them. The financial statements need to be in accordance with GAAP principles, and then outlining when a compilation would occur versus the other financial statement. Those other items, were not in rule, so we have received questions on those previously. We think that those are items, GAAP principles specifically, and the financial statement being within the last year. Potentially, we could put there that the board could waive with good cause, but just for consistency, I think that those need to be in the rules. And then we also want to specifically define what experience looks like for the classification. We've had individuals ask, for license, for the classifications, for their license. They've provided experience, and there are times when the board has said that individual doesn't have experience or they do have experience. So we would specifically like to outline and rule what type of background, work, if you're subcontracting, you're an employee, maybe you have education experience that's relevant. What type of relevant experience can you present to the board to show that you have experience in these classifications? I think it'll help both the applicant as well as the board kind of fetter out those types of situations where someone, maybe they're borderline or they haven't provided information. We'd also like to specifically change, this was something that was in, I think there were some notes, and I think the board has looked at this previously, so forgive me if I'm bringing this back to you, but we had never moved forward on it. There's a rule that says that lines of credit would be looked at for 50% of their value if the individual had negative assets. And there were some notes to increase that to 100% of the value of the line of credit. So that's something the board would like to move forward with. I think that was discussed, but I'm not sure when it was, so I want to make sure if we're going to add to this package that you all approved that. There was a note to change the BCB small commercial, increase that limit to 1.5 million. I'm not sure if that was something that was previously discussed or not with the board, but, and again, if any of these, seem like just far out that you don't want to move forward with these, let me know so I can remove them from the list,
I
but.
thought it was already at that.
It is.
Okay, so that is incorrect then in my notes. Okay, great, so that's one that we can remove from there.
The line of credit would be for working capital.
Correct.
Okay.
Okay, I will pull that one for the small commercial, because my notes weren't correct on that. And then,
I didn't realize that we were only accepting 50% of the line of credit.
that's what it had showed in the rule is 50%. So I'm not sure at what point that was discussed with the board, but that looked like something that hadn't moved forward. And then amending the misconduct rules for contractors and home improvement contractors. Currently, under the rules, there's a requirement that those complaints that are sent to them be sent by certified mail, and that if they don't respond to that by certified mail, that could be misconduct. We would like to amend that to basically use whatever information is in the file and then send that by regular certified or email as appropriate, because there are times where certified mail is not being delivered. There's times where we can find that regular mail has been delivered or email has been delivered. The person has responded by email. And we just think if they provided the information on their licensing file, it's still good contact information to be able to use that as part of the misconduct instead of just saying only if it's been certified mail and has not been responded to. And then the last item, which I think that this has been discussed somewhat with the board as well as with the executive director, but modifying the ability for applications to be approved by the executive director outside of the regularly scheduled meetings. Currently, the law and the rule allow for certain types of license applications and monetary limit applications to be approved by the executive director. Under the rule, that is a temporary approval. I do think it would be appropriate to make that, if it's being delegated to the executive director, just make it a full approval, because realistically, if it was temporary and the board wanted to remove it, unless we're setting a temporary timeline on that, we'd have to go through a formal hearing, so it just makes more sense to do that as a permanent approval, and then specifically outline what types of applications can be approved, whether those are applications for name changes, applications for obviously the increasing of the limit, but change of ownership, change of mode of operation, and then, sorry, I had one more that was on there. And then adding classification as well. So if there's specific limitations that the board would like to consider at this stage or at the rulemaking stage, which would probably be in November, we can discuss that in November as well. But those are the areas that I think that we're looking for authorization for the board to allow those rule changes. And then certainly when we set this for a rulemaking hearing, likely in November after we get the approvals from the governor's office and everyone internally, the board could add further limitations or modify as needed. So, I know there's some people that might be on the spot there thinking, what types of applications would we want to delegate? But those are things that could be considered further before they would go into effect. Are there any specific questions about those or any other areas that the board would like to see rule changes?
At a previous meeting, we discussed whether some of the types of applications needed to be sent to the board member for approval or not.
Right.
And I think we were looking at the BC A little r as one category possibly of not having a board member approve. And then renewals were there.
Yeah, it was like monetary increases. There's the ones you'd mentioned before, minus the classification changes is the ones that we had questions about.
Those are ones that the board would still like to review?
Yeah.
Okay.
The add classes.
And that makes sense. Well, let me ask you
Mode of
this.
operations, name changes, stuff like that. I mean, that's.
Right.
You don't need construction experience to do that.
Right. Okay. I will make that note. And then BCA little r. What about BCB, the small commercial? Is that one that could be delegated to the executive director?
No.
No, you'd like to, okay. Just the limited residential, okay. Are there any other questions or thoughts for discussion?
I guess this question about monetary increases up to a certain limit, over up to 3 million, and if anything is asking for unlimited, go to the board, or any discussion on that, I guess? Kind of threshold on increases, or that?
I'm okay letting you approve any monetary increases. If you have questions about it, you could submit it to one of us, but.
Sure. Okay, thank you.
All right, I'll make those notes. And then it's likely that we would set this for a rulemaking hearing in November, since it has to go through several rounds of approval. And then at that time, the board could discuss if there'd be any further changes before we would move those forward. So if there's any other thoughts on, after this meeting, thoughts on changing delegation to the executive director or any other rules, just make sure to bring those to that meeting so we can discuss those.
Are we, once a board member approves it and emails it back, is the license approved at that point? Or are we Yeah, that's what I thought.
At this stage, right. I was trying to think of, I know there's some of them where there are consent orders that are being sent, and those are not being issued until that is satisfied, but the other ones are being
Right.
approved.
Okay. So it used to be we'd have to wait for the meeting to approve them. Now we're approving them when they come back.
Right. Those ones that have been approved by that board member.
Yeah.
Yes.
And just to clarify, there is some language on the website we will clean up that says something to the effect, please get your application in by the 20th of the board meeting month. We'll get that removed, just to clear up any misconceptions there.
Okay. All right, I think we're good.
All right, thank you.
Any other new business? We have a hearing coming up at 11:30, right?
I believe it's 11 o'clock.
11,
Yes.
okay.
Do we have a hotel for the Knoxville meeting yet?
We do.
We do. The Crown Plaza?
Plaza, yeah.
This is the same one as last year.
Yes.
All right, I'll take a motion for adjournment.
I'll make that motion.
Second.
We're adjourned.
Thank you.